My name is Carl Granrath. I'm the hearing examiner for tonight's hearing. The purpose of tonight's hearing, little bit different from what we usually do, as this is an appeal, as opposed to some of our more typical permit processes. So our, let's just say our order of operation is going to be a little different, and I'll go over that in a second. But the purposes of tonight's hearing is for me to gather evidence and testimony, from which I will compile a recommendation that I forward to the county commissioners, who ultimately have the decision-making authority on this case. So with that, I guess we'll just jump straight into our procedure, as it's a little different from normal. The staff will make a short introduction for tonight's hearing, and then we'll kick it over to the appellant and or their legal representation for their case in chief. And if there's any persons who may appear here in person or via Zoom who wish to voice their support for the appeal, their time will come after the appellant's main case. After that, the county's case in chief will be presented, and anyone who may support them from the public. And then there will be a final opportunity for the appellant to make rebuttal for any comments or anything else they want to address as rebuttal. So with that, just real quick, also for the record, any testimony just from representatives or members of the public, please address your testimony to me, not anyone else in the crowd or any staff members. Of course, try to keep it as nice and civil as possible. I will say that also I do reserve the right to jump around a little bit, call people up and back and forth if I have questions or want to jump around in the procedure a little bit, as we're not following strict rules of procedure or anything like that, or necessarily strict rules of evidence. So with that, I'll get us started. Let's have the county introduce why we're here, and then after that, we'll kick it over to the appellant. So.
Thank you, Mr. Granrath. I'm David Callahan, Kootenai County Community Development Director. And tonight's hearing is an appeal of my decision that a gas station requires a conditional use permit if it's to be located in the light industrial zoning district. The particulars of this case revolve around a specific property in question, but it's largely irrelevant which property we're dealing with, because the same issue applies throughout the entirety of the county. With that, I think that's enough of an introduction. I'll turn it over to the appellant and then wait for my turn.
All right. Thank you. I believe we have the appellant's representative here.
Push this one, yeah. Thank you. My name is Nathan Orlando. I'm here representing the appellant. Outside of the appeal and the documents I were provided with it, the appellant does not have a lot to add to that, but I do think it's necessary to briefly touch upon the background of this particular parcel and the communications that took place. So since late 2019, approximately, representatives from this property have been in communication with the Kootenai County Development and the planners that were assigned to the property in their anticipation of building a gas station on that particular parcel. This has been discussions that have been had since 2019 and goes back as far as something called the Hauser Outreach Project, where with the Kootenai County Development involvement, rezoning took place, and it was identified that this property should be labeled as light industrial, so a gas station could be built as a wholesale, retail, or service business. And this whole process and light industrial tag got placed in approximately the early 2020. So the reason why I bring that up is because the intended use of this property has been known since that time by the people who made the decision that we're here discussing today. And as stated in the appeal, again, I don't want to rehash everything because I respect everybody's time and I'm sure the appeal has been read, but the representatives for this property have been in constant communication with the Kootenai County Development planners and everybody involved, and have relied upon the written correspondence that they've received, including a specific question that was presented by the representative saying, is the CUP required, to which the answer was a no. And that was in 2021, when still nothing has changed with the intended use of the property. And out of the blue, on August 3rd, 3rd, 2022, the reason why we're here today is because an email was received and it was labeled as a decision that a CUP was now being required. And that prompted an appeal, first request for reconsideration based off much of what was labeled in the appeal, including the prior correspondence, prior decisions, and information that was received by the property representatives. And after the August 3rd, 2022 information and new decision was provided, looking at the Kootenai County Code individually, there's just simply no code language that a reasonable property owner could look at and understand, especially with the information and specific written communication that was provided by the Kootenai County Development Committee, that an underground fuel storage requires a conditional use permit. It's just simply not in there. As stated in the appeal, there's multiple areas within the Kootenai County Code that address uses permitted under light industrial and ones that specifically require permitting or other information. 8.2807 has lists and it's titled Uses Requiring a Conditional Use Permit - Light Industrial. There's nothing within that list that states underground fuel storage. The only one that has anything to do with fuel storage is above ground storage of 5,000 gallons of petroleum products. And that's echoed throughout every single list that's within the Kootenai County Code, which is what is authoritative. That includes a table that is uses, and they provide a whole system of which ones require conditional use permit. Again, no information with underground fuel storage, only above ground storage over 5,000 gallons, which is inapplicable to this property, inapplicable to the use that's at issue. Now, a conditional use permit is a means to have public benefit, have mitigation, and there's specific sections within the code that address the benefits for things such as why a conditional use permit might be required for something that's above ground or 5,000 gallons, such as aesthetics, and those are listed. Again, when you look directly at the code, which is why we're here today, it's an interpretation of the code, not everything else. There's just simply nothing that states a property requires a conditional use permit for something that is underground fuel storage. It's just not there. And that is what we're appealing today, and we think that reading an underground fuel storage requirement for a conditional use permit within the lists and within the Kootenai County Code when it's expressly not provided is incorrect. So we're asking this decision be reversed and to allow this project to proceed without a conditional use permit. If you have any questions, I'm happy to answer them.
Sure, yeah. Perhaps I'll save some of the questions. Well, let me ask one now, and I might bring up a couple more later, depending on the county's presentation. So, and just kind of correct me, I don't want to put words in your mouth, but it seems like you want the use, because gas station is not one of the uses in the use matrix, right? This would be pretty straightforward if it just said petroleum fueling station or gas station permitted or conditional use permit, right? So we're trying to figure out which one to slot it into. Your position, your client's position, that it should be the one that's, I'm forgetting the language, general commercial retail service business in the commercial table versus what I'm assuming is the county's interpretation that it should be slotted into petroleum storage of 5,000 or above ground storage of 5,000 gallons or greater. And you think it should be classified as a use of just commercial retail and, again, blanking on the language, commercial retail and service, business.
I actually don't think that's an issue. I think that all the parties agree that a gas station does fall within wholesale, resale, or service business. I think that's agreed upon by everybody. I think it's just strictly whether or not the conditional use permit requirement applies to an underground fuel storage facility, such as a fuel station. I think that's the crux of the issue, and just relying on the code alone, there's just nothing that requires that.
All right, I'm gonna wait for the county to go, and I may have some more questions for you. Thank you very much.
Thank you.
Well, thank you, Mr. Granrath. Before I go into any details, I do want to apologize. I already did in writing by email, and I've made it clear to the representatives of the applicant, and I believe the applicant, that I'm willing to waive the CUP application charges or fees that we normally would charge because the staff erred, and I'm sorry about that. But my responsibility as the director is to uphold what I believe is the proper interpretation of the law. I'm not new to this. I've been doing this sort of work since 1980. I've done it in 5 municipalities, 5 cities, 2 counties. And I'll just quickly mention that out of those municipalities, I was on staff when we rewrote the entire development code for the city of Dallas, for the city of Thornton, for the city of Grand Prairie. The city of Dallas won a national APA award. The city of Grand Prairie won a state award. And so I'm not new to code writing or interpretation. Pat and I actually put together the current code that we're operating under today. There have been 3 major omnibus provisions since that 2016 adoption of our current code. So again, I have some familiarity with these things, and I believe what's really the crux of this issue is, and I agree that what has been said so far is correct. What I think we can't overlook is that here and in all codes that I've been responsible for administrating, you have to read the code in its entirety. The more restrictive always applies. And here we have a case where a particular section of the code, 8.4.1304 F3, expressly says that the storage of any petroleum products exceeding 5,000 gallons requires a CUP. It doesn't say above or below, so you don't get the opportunity to interpret. It's any. So in my view, there's not a lot of interpretation to be made here. This is the plain English language of the code, and we must not overlook the section that requires this. I agree that the code is not a paragon of understandable simplicity, and we continue to work on that. But I think in this particular case, I'm not doing my job if I ignore this section of the code which we've highlighted for you. And so we believe that the correct interpretation is to require a CUP. There's a little more detail than that in the staff report, but I know you've read it, so I won't go into that unless you have questions.
Yeah, and just want to kind of have you help me work through some of the details here, because obviously there are some confusing and contradictory parts of the code. So, so this is not necessarily an issue of classifying the use, and to kind of bring back up what I brought.
I don't think it is at all.
Okay.
To me, it falls directly into the use that was described earlier. No one argues that.
Okay, so then it's not necessarily you using your director's discretion to classify the use
In a different location.
as in
Right.
in the use matrix where it says if it's
Right.
above 5,000, it's in light industrial, then it's a CUP, right? So
Right.
you're not taking that route.
I'm not.
Okay, so it's just the section, I believe, within the light industrial section. that's-
84.1304 F3.
Okay, so it's simply that section that you're,
Yes, sir.
and that provision with, albeit the reference document, and I did review the whole reference document as well for that section. Noticing that the majority of it is above ground storage, but there is later provisions of that have to do with service stations as well. So, and the title of that document being,
The title's misleading, frankly, but it's an old document. It's at this point, and It is
Okay.
what it is.
But yeah, but again, just to nail it down, it's specifically the one section that says in the light industrial, any storage of petroleum products over 5,000 gallons must go through a CUP.
I believe the entire discussion hangs from that thread.
Okay. So I guess just to be thorough here, so when you're getting other applications for gas stations, again, you're applying that commercial use of wholesale, retail, and services, and you're applying that use?
Yes, sir. But I should add that in the 9 years I've been here, this is the only gas station I've been directly involved in.
Okay, that was gonna be my next question.
It's
is how
not
you
something
dealt
that
with-
comes up frequently in this county.
Okay, well, that answers my next question, which would have been how you have dealt with these in previous
And,
situations.
you know, again, if I may, while we're going back and
Please.
forth, I'm sorry the staff erred. But as the director, I have to decide when it's time to step in and correct errors. I believe this is one of those times.
Mr. Granrath and Mr. Callahan?
Is that Mr. Braden? Or,
Yes.
all right, go ahead, sir.
Yeah, I just wanted to make an additional point in addition to fully concurring with the staff report and Mr. Callahan's arguments. I just, there was in the appellant's oral argument, he brought up the issue of the fact that staff had said one thing, that it was a CUP would not be required, and then the director made the determination that it was. I just wanted to cite a Idaho Supreme Court case, Terrasas versus Wayne County, and that's at 147 Idaho 193 and 207 Pacific 3rd 169. And that case out of Blaine County from 2009 expressly stated that the county or city cannot be stopped from asserting a position different than that of their planning and zoning staff. In other words, you know, if the staff errs, the director and the Board of County Commissioners are not bound by that error. So I just wanted to make that legal point, and that's all I had, unless you had questions about that.
Well, thank you. I don't have to go looking for that case now. That was 147 ID 193.
Yes.
Thank you. Anything else, Mr. Callahan?
No, sir, unless you have questions.
I do not at this time. If I think of any in the next few minutes, I reserve the right to ask you.
Thank you.
I
And
suppose
we do have people on Zoom.
I was
so-
just going to say, yeah, I forgot to give an opportunity. I believe perhaps that's the applicant, but there does appear to be someone on Zoom. We can figure out who they are, and I guess they can voice their support or opposition, because we're at that point where I guess they could comment on either.
Yes, sir. So if you'd like, at this point, I'll just ask if anyone on Zoom would like to speak on behalf of the county or the appellant.
Yes, please.
That would be Susan Weeks or Michael Lenz.
Good evening, Mr. Callahan and Mr. Granrath. I am here to speak in support of the director's decision. I am accompanied tonight by the Post Falls Highway District Director of Highways. I am their legal counsel. I just want to join in on expressing concern because this directly affects agencies, including the Highway District, and this is the reason why. Pursuant to Idaho Code Section 67-6512, the county is required to adopt an ordinance for processing applications for special or conditional use permits. And it provides that the county can grant an applicant a special or conditional use permit with conditions subject to the ability of political subdivisions to provide services for the proposed use. Highway districts are political subdivisions, and when we get conditional use permits, we look at the ability of the road system and the accesses available to serve those. We also have the right under that statute to a public hearing to allow us to be heard. So, conditional use permits that impact roads within our jurisdiction are of primary interest to highway districts. This particular parcel lies within the Post Falls Highway District, and when discussions were advanced regarding how the service station would approach the public roads, it became apparent to us that we had an issue where a conditional use permit process had not been followed, which tends then to lead to a concern that the highway districts don't like to utilize, and that is appealing an action of the county as being arbitrary and capricious. We prefer to bring attention to the director when we believe something perhaps has fell outside of the proper protocols. So turning to your land use development code, or your ordinance at 8.4.1304 subsection F, subsection 3, sets forth general performance standards, and in subsection 13, it gives standards applicable to particular zones. And 1304 addresses standards common to light industrial and industrial zones and says that they have to comply with the standards set out in that section. And this property is light industrial. And a particular concern is subsection F, which addresses storage, and subsection 3, storage of petroleum products shall not exceed 5,000 gallons except as may be authorized via approval of a conditional use permit. That is the specific and express language of that subsection. And I do not know specifically that this particular item will exceed 5,000 gallons, but to the extent it does, and most gas stations do, I can say that with personal knowledge. I have represented clients who've developed gas stations. They typically are 30 to 50,000 depending on what they're doing. So it needs to, pursuant to this subsection, conform to the requirements set forth in this subsection G, and that is to be approved through a conditional use permit, even though it's a retail. And that gets us into some statutory construction that courts and other entities that sit in quasi-judicial capacities utilize to harmonize the effect of language in ordinances and statutes. And if there's a conflict, the rules of construction say the specific controls over the general. And in this situation, that is what you are faced with. You have a general one about service and retail that would apply, but then you have specific that addresses storage of petroleum products in excess of 5,000 gallons. And to harmonize that and follow those standardized rules of construction, it requires the application of F3. And as to Mr. Braden's point, I represent multiple governmental entities, and we make mistakes. Staff makes mistakes from time to time. But Idaho law is clear that equitable estoppel may not be invoked against a governmental or public agency functioning in its sovereign or governmental capacity. And that comes from another case, which is Sage Willow versus Idaho Department of Water Resources, 70 Pacific 3rd 669 at page 683, which was issued in 2003. And the Idaho code site for that is, or the Idaho case site for that is 138 Idaho 831. So it's unfortunate that in this instance, incorrect information was provided, but it's important to the public as a whole that the proper protocols be followed and that the agencies be allowed to give their comments so we can address issues in the appropriate format and the appropriate forums. And so the Post Falls Highway District is supporting Mr. Callahan's decision in this matter.
Okay, thank you. I have no questions for you. Thank you, Ms. Weeks. Is there anyone else on the line who may wish to speak? I'm not sure who the cell number is either, or? Oh, okay. Oh, okay. Okay. And as I'm looking like they are not speaking up, then.
Michael, did you have anything you wanted to say?
I'll take silence as a no.
Here he comes.
Oh,
All right. No, I think Susan Weeks basically hit on all points and represented the Post Falls Highway District correctly.
Okay, thank you.
and seeing no other members of the public, let's kick it over to the applicant for their rebuttal.
Thank you. I'd like to first start off by saying, well, I respect what's been said here today, but when you look at the codes and that have been cited, especially Idaho codes 676512, that only applies if a CUP is required, and that's why we're here today. All of those things only apply if a CUP is required, and we're here for appealing the interpretation of the code. And under the code, it's our position that no CUP is required for this type of property. Now, there's some mention about statutory construction and readings and things like that, but I would argue just as much that it cuts both ways, because if you look at F3, that subsection, first off, it does not say the word any. So I would take it upon the hearing examiner to read that in its entirety. But if you look at that, that could be interpreted as the general portion, and the specific portion could be something such as 8.2.807, which has specific lists of when a CUP is required and an underground fuel storage is not. So those type of arguments cut both ways. And when you look at the statute as a property owner, as anybody in the public, about when a CUP is required, it would be unreasonable to interpret the code to say, yes, an underground fuel storage is one of those things. And I understand the equitable estoppel, the cases that were cited there, but that was more of a factual point than anything, that my client, the property owner, had over a year of reliance upon this information that was provided, which they assumed was them looking at the code and them telling them so. And then out of the blue, they get this new denial. There was nothing that prompted that, no new information from our representatives. It was just simply, now this is denied under the same exact code language. So that's why the appeal was brought. I don't have anything further, but I'm happy to try to answer any questions.
Yes, I did have one. I want to make sure I'm, okay, so I do see, the 82807, which I believe is your, and I apologize for having the laptop out, but I don't normally like doing this, but since we're jumping around a lot, we'll have that. And that is what you just referenced as uses requiring a conditional use permit, which is a list. I'm not sure if it's intended to be exhaustive or not, but you did point out that it's above ground storage of gasoline, and again, no mention of underground. In fact, it doesn't seem to, I couldn't really find many mentions of underground storage or gas stations in general. So it is kind of hard to figure out where to shoehorn this in. I hope you'll at least concede that. But, you know, I guess another sort of general question, and I understand the frustration that comes with, you know, prior communications and then something getting switched out of the blue. But, you know, at this point, I guess maybe why, once you get the communication from the county that a CUP is required, why not just go ahead and go through the conditional use process? I mean, it's still a use that's going to be allowed, just with a heightened level review coming in front of me or the other hearing examiner. And generally, it becomes an approved project. So I guess, why fight going through the conditional use process?
It's going to extend the time frame. It's going to add a lot more complication, going to increase costs, all things which were completely avoidable. It's also not expressly required under the code, and there's a lot of different regulations already applied to underground fuel storage, such as DEQ requirements. Those are all things that my representatives of the property has to go through. So there's already uses and checks and balances for this type of system. The code does not expressly require it, so my clients should not have to go through the process.
Okay. Thank you. Well, those are all the questions I had. So seeing as there's no one else and nobody else has just joined us on Zoom, that will conclude tonight's hearing so I will call to the public hearing closed at 6:31 p.m. December 1st, 2022 for Appeal 22-0004. I will have my recommendation to the county within the next 2 weeks, and then it'll get scheduled to go in front of your county commissioners. So with that, thank you all very much for your time and efforts tonight, and have a good night.